I'm very happy to be here. As Stephen mentioned, I'm an attorney, also trained as a psychologist, but I've only been practicing law for the last many years. Uh, and I've been lucky enough to practice exclusively in the area of mental health care law, uh, meaning I only represent mental health care practices, institutes, agencies, practitioners. About half of what I do is what lawyers call transactional, meaning that it doesn't involve courts, it just involves advising, counseling mental health practitioners about business and regulatory and insurance matters. The other half of what I do is litigation work, and that involves representing mental health practitioners in professional licensing board proceedings before the New York State boards for social work, psychology, mental health counseling, and the Mental Health Practitioners Board, in addition, sometimes before the medical board representing psychiatrists. So that's what I draw upon, and the experience I draw upon in presenting to you today, confidentiality and privilege with minors. The first issue that comes up with minors, as with all patients, is informed consent. Informed consent is an ethical requirement. It's a professional requirement of New York State that is required by regulations that govern licensure. It's also governed by statute in New York State. It's a common law obligation. Essentially, it means that you have to get folks to agree before you proceed to treat them. The elements of that agreement are that they should know the nature and purpose of treatment. They should know the risks and benefits of treatment. They should know the alternatives to treatment, including the alternative of no treatment at all. And for psychotherapy practice, there is an additional requirement in the nature of a disclaimer, meaning that you have to disabuse folks legally, it's a legal requirement of what they might reasonably infer regarding confidentiality. In other words, you have to let them know the limits of confidentiality in psychotherapy practice. Now, in order to give informed consent, someone must be competent. In New York State, that means that the person who gives informed consent to treatment either has to be 18 years of age, him or herself, or if the patient is under the age of 18, then a parent or guardian of that minor would have to give informed consent on behalf of the minor. The minor cannot give informed consent to his or her own treatment. There are exceptions. The exceptions are when minors can themselves give consent to treatment, and those include when the minor is a parent, him or herself, when the minor is married, when the minor is in the armed forces, when the minor is emancipated meaning not living with or receiving financial support from the parents or others, and lastly, pregnant girls who are seeking prenatal counseling. But generally, if a pregnant girl is in treatment with you, you can assume that prenatal counseling is an aspect of the treatment. So in those cases, you would also not look for consent from somebody of majority, but rather accept it from the minor. Now, one of the misconceptions that many clinicians have with regard to treating minors is that minors, like folks who are of age, can be granted confidentiality as if they were adults. That may be the case, but only if you have expressed consent from their parents to treat them as such. Let me explain what I mean by that. Ongoing informed consent, including those elements that I mentioned earlier, nature and purpose, alternatives, risks, benefits, and such, that is required on an ongoing basis of children and of adults. In other words, parents who give consent on behalf of their child for you to treat their child need to know on an ongoing basis what the nature and purpose of treatment is, what the risks, what the benefits are and such. they cannot be, the information that you give parents on an ongoing basis cannot be limited to imminent risks of danger to self or others. We've had to represent quite a number of therapists and licensing board proceedings who are under the misapprehension that the parents' information about the child's treatment can be withheld from parents unless the child is at imminent risk of danger to self or others. That is not the case unless the parent has expressly waived the right to ongoing informed consent to in the treatment of a minor. The problems arise with sex, drugs, and sometimes petty criminality. In other words, well, I shouldn't say that those are not the only instances where problems arise. Problems also arise sometimes with symptoms. Let me give you some examples. If in New York State the age of consent is 17. In other words, somebody under the age of 17 cannot consent to sexual behavior. Now there is a relative exception called what some people call the Romeo and Juliet exception, meaning that minors who are over the age of 13, under the age of 18, within 3 years of each other, without coercion, that even though there's no consent element as is ordinarily necessary, and technically it may be sexual abuse of one kind or another, they don't prosecute it. But nevertheless, if you're treating a child under the age of 17 and they're sexually active, the parents ought to know about that. And that's not information you can safely withhold. We have had to defend therapists in licensing board proceedings who have withheld that information, and when parents have subsequently found out, then the parents have complained to the board, and the therapists have had to defend themselves. I don't mean to say that a defense is impossible. We have, in quite a number of instances actually, been able to defend, but never has the board said that that's appropriate conduct on the part of the therapist. What they have said in some instances is it's simply negligent, and simple negligence is not professional misconduct in New York. It's got to be gross negligence. But nevertheless, it's not something you can withhold. Certainly not if it's sexual activity that doesn't fit within that Romeo and Juliet exception I mentioned. In other words, if your child patient under the age of 17 is sexually active, but is sexually active with somebody over the age of 18, that's something that the parents need to know about. Now, likewise, if a child is experimenting with drugs, even if it doesn't, as far as you're concerned, reach the threshold of a diagnosable alcohol use or substance use disorder, the parents need to know about it, because that is an issue. Remember, the nature and purpose of treatment means whatever is a significant issue need be acknowledged to and understood by the guardians or parents. Petty criminality of such, and also the parents need to know of anything that is clearly symptomatic, even if it hadn't arisen earlier. We've had a number of cases where kids were cutting, and for some reason clinicians withheld that information from parents. Can't be done. That's necessary. Now, necessary information for a parent in order to have been given appropriate consent. Now, I did say earlier that a waiver is necessary, but the waiver, in order to be effective, has to be explicit. In other words, you've got to tell parents when they first come, if say they're bringing a 17-year-old to treatment, you'd have to say to the parents, listen, I want to treat your 17-year-old as if she were an adult, meaning that I don't want to have to tell you anything about what goes on between us in treatment unless I believe she's at imminent risk of danger to self or others. Then of course I'll tell you, but otherwise not. Is that okay with you? And he even gets so explicit as to say that means I'm not going to tell you if she's sexually active, but there's no coercion involved. I'm not going to tell you if she's experimenting with drugs, but I don't think there's any use disorder there. We've been asked by clients, usually agencies, to put that in writing, but no parent would ever sign it when it was put in writing. But if you can get it orally from the patient, from your minor patient's parent, and note in the record, that should be adequate to protect you. Okay. Now, the issue sometimes arises with regard to which of parents might need give consent. Uh, in, in the vast majority of cases with separated or divorced parents in New York State, uh, there is joint legal custody. Custody is actually separated into two aspects in divorce or separated or unmarried parents. There is physical custody, meaning time sharing. Where does the kid primarily reside? And then there is legal custody having to do with decision making. As I said, most of the time, decision making is joint. In other words, the parents are jointly tasked with making decisions regarding the children's education, health, religious upbringing are the important ones, important areas. So the question sometimes arises, what happens when, it's usually mom, so I'll use the stereotype. What happens if mom brings Junior for treatment and says, Dad's not involved, please don't talk to Dad. We're divorced and he doesn't understand the child's need for care and he's even averse to psychotherapy. Can I proceed to treat the child? Well, the answer is legally, yes, although from a risk management perspective, it would be ill-advised for you to do so or to agree to do so. Well, let me explain that. Legally, one custodial parent, legal custodial parent, one parent who has decision-making capacity is all that's necessary to give consent to a child receiving care. However, either parent, either joint custodial parent can then withdraw consent. Meaning that, again, using my stereotype, if mom says, okay, treat Junior, and you don't tell Dad about it, and you treat Junior without telling Dad, Dad finds out about it, and Dad calls says, you got to stop, you got to stop. Also, we've had quite a number of necessary defenses in those situations where the other parent, the uninvolved parent, finds out about the treatment of which he or she was not advised by the therapist and complains to the licensing board that the therapist proceeded to treat their child without their consent. Now, as I mentioned to you, that's not illegal, it's not unprofessional that you began the treatment without the other parent's consent. However, and here's the problem, to my mind, the licensing board will at that point question the standard of care, not the legalities as such, but the standard of care, whether you followed best practices in treating a child without at least attempting to obtain the consent, collaboration, cooperation of both parents, under the belief by most child clinicians that therapy with a child has the best chance of success if both parents are involved. So the question is, why didn't you at least try to elicit the involvement? It was your decision to make. It was not a decision that you could delegate to the other parent. It's up to you as the clinician to tell the other parent, no, if I'm going to do the best job I can with your kid, I do have to get the other parent involved as at least as an informant to let them know what's involved, what I'm going to do with their child. Sometimes the issue arises as well. I'm not sure who is the joint custodial parent or what's necessary. I have to check the legal documents, right? No, you do not. New York State expressly does not want mental health clinicians to be looking at separation agreements or divorce decrees to try to figure out who can authorize what. New York State expressly permits and encourages you to accept, and it may require written acknowledgement, but to accept from parents their statements as to what the legal custodial status is of their child in order to give or not consent to treatment. All right, moving along. Child abuse and neglect. Child abuse and neglect are, of course, I assume, well understood by all of you. You're all mandated reporters. Uh, there are some issues that come up with children uh, that I think are potentially problematic with regard to the confidentiality in their care. The first issue has to do with the evidentiary standard. When has enough evidence been presented that you do need to make a report because the mandate is triggered? In New York, that is reasonable cause to suspect abuse or neglect. Um, Now, reasonable cause to suspect is a very low evidentiary standard. You're familiar with beyond a reasonable doubt, the standard used in criminal cases. That would be a 90+ percentage certainty level. Maybe you're familiar with clear and convincing evidence. That's the standard used in family courts for termination of parental rights and other courts for when significant rights are involved in the removal of certain rights. That's about a 75% threshold, clear and convincing evidence. There's another standard called preponderance of the evidence. That's like a 51%, or what courts call a scintilla of evidence, more that something happened than not. And there's probable cause, some of you might have heard. That's what a cop needs to stop you. That may be a 35% chance, a certainty level. But reasonable cause to suspect is below that. So it's like a 10-20% certainty level. So you do the mandate is triggered uh, uh, whenever you have even a very low certainty level that it actually occurred. Sometimes this happens in divorce situations where a child will tell you that one of the other parents did something, and you're pretty sure from what the kid's language, the parroting adult language, uh, or some other aspect that indicates possible alienation, that that it didn't happen, but the kid is saying it. If the kid says it, that something happened, you really don't have the prerogative, given that evidentiary standard, to say, I'm not going to report this. I don't believe it. If the child or a parent directly tells you that abuse or neglect might have occurred, then you must report it in New York State. Another issue of confusion regarding child abuse and neglect in New York State has to do with uh, uh, who is an appropriate subject of a report. New York has adhered pretty much to the original intent of child abuse reporting laws, where the subjects of reports can only be parents or legally responsible persons. Legally responsible persons are persons who are delegated parental responsibility by a parent, meaning a nanny who takes care of the children, or a paramour, live-in paramour, who also is responsible for childcare, or a sibling over the age of 18 who regularly cares for the child. A legally responsible person is not a school teacher or somebody else who has it's not a school teacher, because although they're legally responsible for the children in their charge, they are in loco parentis teachers by operation of law, not because the parents have personally chosen and delegated parental responsibility to them. The reason this comes up, and not infrequently actually, is crimes against children committed by other than parents or legally responsible persons. We've had to defend a number of therapists who report crimes against children to the CPS under the mistaken belief that any crime against a child has to be reported. That's not the case in New York State. It is the case in many other states that have expanded the reporting requirement, but in New York State, the reporting requirement only involves can only involve as subjects parents or legally responsible persons. For example, we had to defend a psychologist who was brought a 7-year-old boy who'd been sexually abused by his karate teacher, and the parents did exactly what they should have done. They immediately stopped the karate lessons and the child having any kind of access to the karate teacher, and they brought the child for treatment. The psychologist mistakenly believed that had to be reported to the state, and did so by calling the hotline, which technically was a breach of confidentiality because it wasn't covered by the mandate. You might say, well, Why did they accept the report up there at the registry if it wasn't mandatory? That's because, again, unfortunately, New York's hotline is for reporting not just abuse and neglect by parents against children, but they also accept reports of all crimes, which they refer not to CPS and ACS and DSS. They also accept crimes, reports of crimes against children, and report them to the state police for investigation. The other area that's sometimes confusing to clinicians with regard to child abuse reporting involves the reporter, the informant about the abuse. New York says that you have to have a professional relationship with the child or the parent of the child in order for the mandate to be triggered. In other words, the law doesn't appoint you as sort of all-purpose vigilantes to report any abuse and neglect that might, or possible abuse and neglect that might come to your attention. Only if you have a professional relationship with the child or with the parent of a child, and they report to you reasonable cause to suspect, is the mandate triggered. No, sometimes, oftentimes actually, we'll get calls from a therapist who'll say, "Gee, my patient, she tells me that her best friend has disclosed to her that a parent is molesting her, father's molesting her. I now know about some child abuse. I have to report that, right?" No. You don't have a professional relationship with your patient's friend, so no, it's not a mandatory report, and certainly not. It's not even advisable that you do report. Because you can get into difficulty with regard to defamation if you do. New York does have another mandate now. Since the Sandy Hook shootings, New York passed what's called the SAFE Act. The SAFE Act is an odd duck. It's sort of it's New York's version of something like the Tarasoff principle, but not. The Tarasoff principle, as you may know, is in many states by statute, in some states by court precedent, but not actually in New York State by either of those. What New York has is the SAFE Act, and under the guidelines of the SAFE Act, psychologists and social workers, not mental health practitioners, but psychologists and social workers are required to report to the Department of Criminal Justice, and it's a report made on a computer, not like a child abuse report made by telephone. It's a report made on the computer. When you have reason to believe that a patient is at imminent risk of danger to self or others, you are required to report to the Department of Criminal Justice, which is tasked specifically and exclusively with then ascertaining whether the person you're reporting, who has to be a patient, has a firearms license, and if so, to have their firearms removed, or if they haven't applied for a firearms license, then the Department of Criminal Justice will put their name on a list so that if they apply for a license, they'll have to petition a court to have a court review the report and their fitness to be granted the license at that time. Now, some people don't think that law applies to minors. It does. If a minor is at imminent risk of danger to self or others, you got to make the SAFE Act report, minor or not. A lot of folks are under the misapprehension that if the minor doesn't have or have access to firearms, you don't have to report. That also is incorrect. Regardless of access to firearms, ownership of firearms presence, that doesn't matter. You got to report to the Department of Criminal Justice when there's imminent risk of danger to self or others, so that they have on record that the child is at imminent risk. Now, what does that mean in terms of your ethical requirement? Not legal in New York State, but ethical and possibly legal. No court has really given a definitive opinion, but possibly legal requirement. If a child is an imminent risk of danger to self or others, do you take action to prevent them from suiciding or committing homicide? Well, yes, you do, but you do it as you would expect to do it, not by calling the authorities, the Department of Criminal Justice, but rather by calling, if it's homicide, calling the intended and writing the intended third party victim and letting them know that you're treating so and so, and that you believe that the child might be at risk to them, or telling the parents if the child is at risk of suicide, telling the parents as well if the child is at risk of homicide, and also notifying the police, notifying the police that of the imminent risk of danger that you believe the child presents to others, if the parent hasn't taken immediate protective action. Ordinarily, that would mean hospitalizing the child, even if involuntarily. What I'm getting at here is that the SAFE Act report is not a substitute for taking whatever other action may be necessary to prevent a child from hurting him or herself or hurting others. That other action, ordinarily involving authorities, the parents, and any third-party victims, is necessary. Okay. Access to the records of children. New York State, HIPAA, does have a requirement that parents be granted access to the treatment records of their children in the same way that all patients have access to their own records. That is, it's unprofessional conduct in New York State not to grant parents access to the records of their children if they request it, or alternatively to deny it, but to deny it for one of the reasons allowed by and on the form promulgated by the Department of Health. Now, you can not give a parent the records of a child's treatment if you believe that doing so would damage the child's relationship with you or the child's relationship with the parents, or that's one of the reasons. Another reason would be if the child, if you think that releasing the information would endanger the child or someone else. If the child is over the age of 12, there's also the reason, probably it's in New York State law, but not in HIPAA, so it's unclear whether it really does apply. If a child is over the age of 12 and tells you not to release to their parents, and even if it might not meet one of the other criteria, that you could withhold the records from the parents on that basis. But again, if you're going to withhold access to the parents, to the child's record, you have to do it on the form that's been promulgated by the state. Otherwise, you can be charged with unprofessional conduct. Now, do not mistake this right you have to withhold treatment records from the parents with a right to not to tell parents anything about the treatment. Keep in mind that obligation I mentioned earlier about ongoing informed consent. Parents have a right under public health law regardless of their custodial status, to information about their child's treatment. But you can't tell a parent that you're not going to tell them anything about their child's treatment. You got to give them what's necessary in order to maintain informed consent. You may be able to deny records, assuming that the access to records. So another mistake sometimes that clinicians make is telling minor patients' parents, if they want the records, they're going to have to sign a consent form, a fancy consent form that you devised. No good. If parents want their children's records, all they have to do is give you a signed, dated request in writing. Now that's something. It's not nothing. Meaning that they can't send you a text or tell you by phone or send you an email unless it's a PDF that's signed. They got to put it in writing, signed and dated. That's what New York's access law says, Section 18 of our public health law. All right, now on time here. All right, now you will.
11 minutes until the 15 minutes for Q&A.
Okay, thank you. Now you will, unfortunately, sometimes have be asked or be expected to get involved with parents' disputes, legal disputes involving parenting, fitness, custody, visitation, when you're treating a child. The first thing you want to make sure of is that in obtaining informed consent to treatment of the child, you disabuse the parents of the notion that you're going to be involved in any forensic manner in any legal dispute. By forensic, involved forensically, I mean forensic means that you're going to address legal issues that are involved, the legal issues involving fitness, custody, visitation, and such. You're going to let them know that you, as the child's therapist, cannot get involved in those decisions in a court. Now, we do have informed consent forms. I'm sure you've seen them all, in which you ask parents to acknowledge that you're not going to get involved. Those have moral authority, but you can't take away a parent's right to subpoena you if that's what they're intent on doing. I mean, some courts, if you show them an informed consent form in which the parents have indicated that they won't call you as a witness, and nevertheless they do, some courts will say there's a moral authority to that agreement that they signed, and will ask the parents to justify why they violated the agreement they made, particularly if the rationale for the agreement is also given, namely that you want to protect the privacy of the child's treatment. Now, the child's treatment records may well be subpoenaed if there is a custody or divorce proceeding. There is unfortunately a split of opinion in New York State as to whether, if you receive a parent's authorization for the release of records in the context of a divorce or custody proceeding, that you can and must release those records. Under HIPAA, it would seem to be the case that you can and should release the records in the same way that you can or should release records with parental authorization in any other situation, unless, of course, you believe it would be harmful to the child. There's a case up in Rochester where a court said that a child's records should not be released, even with parent authorization, in the context of a custody or visitation dispute, because of the intrusion into the privacy of the child, and that the court should review whether that intrusion into the child's therapy is justified. Obviously, the preference always here is that there be a forensic evaluator appointed to whom you would contribute information, but not yourself be called upon to testify.
Bruce, does this get to the issue, though, of testifying as an expert witness versus testifying to facts?
That's what I'm going to get at right now, Stephen. You're giving me my segue I need. Thank you. If you are called to testify, which may happen regardless, you may. Now, I do recommend that if you do get a subpoena, whether it's a subpoena ducis tecum, which is for records in New York, or a testificanum, which is to testify, that you do consult with an attorney. Those of you on malpractice insurance, the consultation is a covered charge. They will reimburse you for an attorney consultation. But the attorney will, first of all, try to make sure that the lawyers understand the limits of the testimony you can give. And then if the lawyers nevertheless insist on enforcing the subpoena and calling you into court, help you ensure that you don't get into trouble by going beyond the scope of your role or beyond the scope of your competence. And that has to do with what Steve just alluded to, limiting you as a fact witness treating doctor, not a forensic or expert witness. That's a whole lot of words. Let me try to explain what they all mean. Generally speaking, fact witnesses do not give opinions. Witnesses in trials do not give opinions. In other words, if you are a witness to an automobile accident and you're called to testify, you can say whether you saw the light was red or green. You can say whether it was raining or not, but you're not, as a witness, supposed to say, "Oh, I think that was the guy at fault." That's not an opinion that a fact witness, who are the ordinary witnesses in any legal case, are entitled to. Now, there are certain special witnesses called expert witnesses who are allowed to give expert testimony, but that's not you. That's not you in a custody or visitation case. Why? Because it's beyond the scope of your role and beyond the scope of your competence. Let me explain. Beyond the scope of your role means you're the child's therapist. You got nothing to say about anybody else. If you're going to give an opinion about fitness, custody, visitation, you are at least indirectly, if not directly, assessing persons who were not your patients, namely the parents. Collateral contact does not give you permission to diagnose or assess in any way the parents of a child who is your patient. So you're beyond the scope of your role if you give any testimony with regard to visitation, custody, parenting, fitness, anything like that. And that you're not limiting yourself to the person who is your patient. Sort of like the Goldwater rule, those of you familiar with that. It's also beyond the scope of your competence in two ways. Number one, if you're going to give an expert opinion, then implicit in that expert opinion is your impartiality, right? You can't be impartial when you have a therapeutic relationship. It's technically a dual relationship. To purport to be an objective evaluator when you already have a pre-existing relationship, a therapeutic relationship, the two don't jive. In other words, if you have a 16-year-old patient and he says, I want to live with dad, and by golly, your opinion is that he should live with mom. You can't give an expert opinion or come to any expert assessment with regard to that, because if you tell the court that he should live with mom because you think she's the better parent, then you've jeopardized your relationship with the child, the therapeutic relationship, which is an unethical thing to do given your primary role as therapist. But the more important reason why that you're going beyond the competence is that to give an opinion with regard to parenting, fitness, custody or visitation requires the code of ethics, the specialty guidelines. They require you to have evaluated in a very particular manner, having to do with observation, testing, procedures, all of the parties involved, and you haven't done that. So you're not competent by reason of the ethics of the situation and by the standards of care to give any kind of expert opinion. Now, you might say, so that means all I testify to is facts, right? Not exactly. Remember I said that you are a fact witness treating doctor, which is a special kind of fact witness. So there are two opinions, and only two, that you can give as a fact witness treating doctor, and they are therapeutic diagnosis and therapeutic prognosis of your patient. Meaning that if you're treating Junior, you can say, Junior told me this, Junior, I observed this of Junior. If you're asked for opinions about custody, you'd avoid that. You'd say, I have no opinion in that regard. But if you were asked an opinion with regard to your diagnosis and therapeutic prognosis of Junior, you would give that, even though those are opinions, because you are a special kind of fact witness, a treating doctor, what's called treating doctor, treating clinician fact witness, you would give those two opinions and only those two opinions. And with that, we'll go to questions, I think.
Fantastic. And there are plenty of them. And I know from experience that the questions that come in for this kind of topic are always 2 and 3 paragraph questions. They're not simple questions. So Bruce, first of all, thank you so much. I think everybody probably already has a headache and like 5, 6 cases they're thinking of, oh geez, what do I do? I think one thing you said in passing that I want to reiterate as a senior clinician, there are people like you who specialize in this work. And if you're not sure what to do, it's a really good investment of your resources to consult with an attorney before you do the thing that might actually be actionable, either from an ethical point of view or a state license board point of view. So, and Bruce, I didn't know what you said a minute ago, that with your malpractice, at least for the purposes of being subpoenaed, that a consultation is a reimbursable expense.
Yes, if you have insurance with the APA Trust or with American Professional Agency, which the majority of psychologists do, then they will pay for your attorney. They'll actually reimburse you for an attorney of your choice, with whom you consult when you receive a subpoena. If you have the NASW assurance, they will assign one of their attorneys.
Right, but at least you get a professional opinion.
But you get a professional opinion. The subpoenas are highly technical documents these days. You really need to give them. I mean, just yesterday I had someone send me what she thought was a subpoena, but it was an order to show cause, and she was going to send them the documents until she called her insurance company and said, no, talk to a lawyer, and they referred to me, and I told her, no, I have an OPD case that I have a conference on later today, having to do with a poor psychologist who, when a judge suggested to her that she knew the child better than anybody else, and how could she possibly have no opinion with regard to which of the parents is better suited to be the guardian of the child? She said, well, the judge is telling me to, I guess I ought to know, and said something, and ended up with a professional disciplinary complaint against her by the other parent for giving an incompetent opinion, given that he had no input into it. So yeah, it's like what you tell your patients: seek help.
Yes.
Yeah.
I also want to reiterate what you said about contacting non-custodial parents or the parent that doesn't bring the child to treatment. My practice is exclusively kids. I've been licensed since 1986. And I see many therapists I know, and certainly trainees, who don't think that you have at least an obligation to reach out to the person, regardless of what parent number one tells you. I had that happen this week, and the other parent thanked me for including me in the process. He said, I don't think my child needs therapy, but I'm not going to get in the way. Return the rating forms that I asked him to fill out. And so I think we're well advised not to assume the bad intentions or the lack of involvement of the parent who doesn't bring in. But a follow-up question from a friend and colleague, Dr. Jeffries. When one parent consents and then the other parent doesn't consent, is it allowable to say, I'm only going to treat if you both agree? In other words, you started with one and then the other withdraws the consent. Can you set up a standard like that a priori?
Well, yes, and I believe you should. That you should tell the parents that you need the consent of both of them in order to begin and to continue the treatment of the child. And then if one of them withdraws consent, have it set as a precondition of treatment that at that point you will withdraw. Now you might say, well, that's bad for the kid. The point here is, from a risk management perspective, which is really what I'm giving you, you don't want to get into a fight between the parents. You want to leave the fight between them where it belongs. You don't, because if you continue that over a parent's objection, they're going to attack you. Count on it. It's going to be a complaint to the licensing board. And even if you're exonerated, you will have gone through months of worry and upset. And if your records aren't good, there could end up being a sanction just for that reason. What should happen in that case is, if one parent says Junior needs treatment and the other parent says no, and you get in the middle, you withdraw, and then the parent who wishes to have the treatment for the child is supposed to go to his or her lawyer and say, this child needs care. I have a letter from Dr. So-and-so or Miss So-and-so that the child needs care, because when you terminate with the child, you are going to send a letter to both parents. I'm withdrawing because one of you has withdrawn consent, but I do believe your child is in need of ongoing care. They're going to take that letter to the judge, and they're going to say, I want the other parent, the obstructionist, I want that person removed as a joint custodial parent with regard to mental health decision-making. That's where the fight belongs, in court between the two parents, not with you as a potential victim.
And that happened to me last year, and we had this conversation, and that's what I had to do. And it's
Yeah.
unpleasant as a therapist because you feel like you're not caring for the patient, but it is what has to happen. So uh, I appreciate the legal aspect of that. Bruce, what is the current status of this thing called psychotherapy notes?
Are you talking about the open notes law, the new open notes law, or
Yeah.
psycho?
No, not the new open notes law. That's the one that took effect April 5th, right?
Yeah.
Is there such a thing as notes on the side that don't become part of the medical record?
Yes.
What some
Yes.
people call process notes.
Yes. 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 Under HIPAA, they're called, unfortunately, called psychotherapy notes. Very misleading.
Yes.
Under state law, they're called personal notes and observations. And as Steve just said, colloquially, they're usually known as process notes. Those are notes defined as notes kept in addition to and separate from progress notes, which contain information that's not immediately relevant to diagnosis or treatment. If you keep such notes, and the vast majority of my clients anyway don't, but if you do keep such notes, they are generally protected from disclosure to the parents in access requests or even to courts when records are subpoenaed. Most courts nowadays will respect the privacy of those psychotherapy notes or personal notes and observations or process notes.
And can they, should be, or must they not be kept as a part of the same physical, electronic, or paper medical record?
They're kept in the same file, but they're explicitly labeled as psychotherapy notes. Most, I haven't seen any that don't actually. EHR programs have a separate folder for psychotherapy notes.
Right.
Yeah.
Bruce, can you explain to people what happened on April 5th that's relevant to the practice of psychotherapy?
Well, the open notes law modified HIPAA. It used to be that under HIPAA in New York State, parents had a right to access, or patients as well, access to the records within 10 days of their receipt of the request by the practitioner. Under HIPAA, it was 30 days. The open notes law changed the HIPAA law that said that if you have an EHR program, and if that EHR program has a portal that allows patients to communicate directly, then that, and to access records, you have to open that, leave that portal open to enable them to access their records immediately upon their request to do so. Most clinicians either don't have EHR programs that have such a portal, or they keep paper records, so it doesn't apply to them. But there are some within large practices where they do have such a portal, and you can't disable it. If you don't have such a portal, you don't have to install it, but you can't disable it if you have it. What it also necessitates prior action on your part with regard to those reasons that we discussed earlier about denying access. In other words, if you think that the parent should not be allowed access to certain records, you would separate them in the portal from the records to which the parent has access, and you put in a separate folder, notes that are redacted notes, a separate category of notes, not psychotherapy notes, but redacted notes.
Interesting question came in. Can the speaker clarify the need to disclose substance abuse and sexual behavior to parents? We were told in a major hospital system that it was the law that you cannot disclose sexual behavior to parents if teen is over 14 unless risk of exploitation. Additionally, that substance abuse, unless life-threatening, was something that you could disclose to parents if a teen did not.
I don't know what to tell you about that, except you were told wrong.
And when you can,
I shouldn't say that. In New York State, our mental hygiene law has a particular provision that allows entities with operating certificates, OMH, OASIS, to treat minors without their parents' consent if certain determinations are made by a psychiatrist actually at that institution. That may be what you're referring to, but it's not a right extended to private practitioners.
So let's take the common situation. There's a 13-year-old or 15-year-old, let's say, first experimenting with sex, drugs, maybe putting scissors to their arm, but not engaged in bloodletting, cutting. The parents are required to know that information. Is the aspirational standard, in your opinion, to try and get the teen to either give you consent to share that with the parents or to have them consent to do that with you? What would be the aspirational standard, or some of your thoughts about a situation like that?
To my mind, the aspirational standard would be not to promise to the minor what you can't deliver in terms of confidentiality, but to tell them that if they do tell you anything that you think, it's more based on trust than on confidentiality, that you think as someone who cares about them, but who respects the parent's role as such, that you may have to involve the parents, but that you'll do so in a manner that is hopefully therapeutic. I think that it is aspirational that the child be involved. But keep in mind, from a legal risk management point of view, a minor cannot complain about you, not in court, not to the OPD, the licensing board, not to an ethics committee. They're not competent, legally competent to do so. Those entities cannot entertain complaints by minors, but they readily accept complaints from parents. There's not the protective, the defensive action to take is not to believe that there's some sort of ethical obligation, because ethics defers to legal obligations in almost all cases.
I think what therapists are worried about, that supervisors and colleagues have to help them think through, is they're worried that then the kid will start not using therapy as a place to disclose important information, but it's a risk we have to take.
I believe so. From yes, from a risk management and legal perspective, that is the case. From having defended so many therapists who believe otherwise, and then are held accountable for not obtaining informed consent from the parents to treat their children.
You rattled off your tongue because it's second nature to you. It's muscle memory to you. Nature and purpose. What was some of the other things that you specified as you went through the elements of consent?
The nature and purpose of treatment, the risks and benefits, the alternatives, including the alternative of no treatment at all, and the limits of confidentiality. Those are the four elements of informed consent to mental health care.
Which I think includes specifically then the risks of undertreating or not treating.
Yeah, I mean, I would hope most clinicians have some understanding of the meta studies having to do with the effectiveness of treatment and of no treatment, and give that at least to the parents, that with treatment 2/3 get better, without treatment 2/3 either get worse or stay the same, or something like that. Whatever in your field is the acknowledged benefit.
Right. Let me end on this last question. We'll get through as much of it as we can. Thanks so much for doing this. Let's say I would be a pediatric psychologist working in a New York State hospital with families of children with behavior problems. Let's say the focus is parent education and behavioral parent training. In this setting, if parents have joint custody, could a parent with joint custody refuse the other parent receiving parent training, given that the patient is the child? I think that simply the answer is no. They have no, yeah. Or could this prejudice to the consenting parent who wants treatment to support their child?
No, it's up to you as the clinician to formulate the treatment plan and to insist on compliance with it. And if compliance is refused, then to decline to offer or to withdraw from treatment.
I'm going to end on this one last question. Bruce, you've unfortunately had to defend lots and lots of therapists over the years. Top 5 mistakes in ongoing therapy notes.
Not keeping any notes at all would be the biggest one. The second would be focusing in notes exclusively on what the patient said, rather than on what you did and why you did it, and your assessment of the efficacy of the interventions that you made. That would be the second most. The third would be the lack of a treatment plan. That's happened in the last few years. It used to be that when clinicians' records were reviewed, peer reviewers were willing to sort of try to glean from progress notes some sort of implicit treatment plan. Nowadays, no good. They want to see something explicitly called treatment plan. They want to see your reference back to it in the progress note and changes, modifications based on the patient's response. It has to do with the medicalization of the profession, really, and the standards of medical record keeping being imposed on mental health care, which don't often fit for some orientations. They don't fit that so well. But those would be the top ones. Another one often cited by insurance companies is they call it note cloning. In other words, it looks to them like you just repeated a note to note, the same thing over and over again. You really have to think about what's happened on a given day in your exchange with the patient, and try to figure out how to write it down, and not just in a cliched way.
My EMR EHR actually has a clone note feature, so I have to override it and add something that shows, something of meaning for that day. Bruce, thank you so